Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about another attack, basically, on our democratic principles and another item that has been done under Trump through Attorney General Sessions. Let me explain, and then how we can fight it and how we can prepare for what's going to happen. So, normally, the Attorney General of the United States does not specifically take cases from the Board of Immigration Appeals and essentially tell them being all the judges, all the people who actually hear the cases and make the cases, that their ruling isn't going to matter, that he, the Attorney General, will overrule it, and it'll be like he says from then on. So one of the elements that immigration judges have is their discretion, their ability to make decisions without being hampered by essentially procedures or lack of procedures, which essentially streamline the whole process, thereby denying due process to the person actually appealing in the first place. So one of the discretionary items that a judge has, an immigration judge, is called administrative closure. And there's all kinds of reasons that a judge may want to do administrative closure. A judge may want to do administrative closure because the person will qualify for relief in 2 or 3 years and essentially may not have any criminal history, been here for 20 years, have everything lined up, but is just waiting for the visa number to become current. It may be because the person received TPS from a country and they are safe, maybe because they qualify for a U visa, an S visa, a T visa, maybe because of humanitarian reasons. It goes on and on. Well, and that's in the discretion of the judge to determine if it merits administratively closing the case. Now, with administrative closure, that means that the court still retains jurisdiction, but the case is closed, deportation proceedings is not happening, and then once in the future the events come up which actually allow the case to proceed, then the case can be recalendared. It doesn't even have to be reopened because it hasn't been terminated or a final decision has not been made. So Attorney General Sessions has just made the decision that, except under very narrow circumstances, the immigration judges no longer can issue administrative closure orders. So, one person, the Attorney General, who seeks to get people deported as fast as they can without due process, has issued this admin closure order thinking that's going to happen, but it's not. The procedures and what will happen because of this are actually going to have the opposite effect. And let me explain. If, let's say, somebody qualified for something in 2 or 3 years, and the judge would have admin closed the case in order for those 2 or 3 years to pass, and then get the case recalendared for adjustment. Let's just say that now, because the judge can't do that, the judge is going to issue a removal order to remove this person. Well, what's the first thing that's going to happen? Well, what will happen is the person will then file an appeal to the Board of Immigration Appeals, claiming that it was an abuse of discretion not to either continue the case or admin close the case. And that's another point. The judge may just continue the case for 2 years rather than admin close it. But in any event, it'll go up to the BIA. Let's say the BIA denies it. It'll go up to the Circuit Court of Appeals. Let's say they deny it. They could do a petition for rehearing en banc, could do a motion for reopen back at the BIA. There's all kinds of stuff that will happen because they can't admin close the case. If the judges admin closed the case, then that would have been all the litigation until the visa number became current and the person could go forward. But now, obviously, the person will not just say, oh, yep, you're right, I'm going to leave the country, leave my family, never come back. That won't happen. They'll legally fight how they can, and that's to appeal and then do a petition for review. So in effect, what Attorney Sessions has done, General Sessions has done, in his attempt to try to speed up the deportation process and to get more removal orders, he basically now has created much more litigation at the appellate level and at the circuit court level. And ultimately, that will go back down to the immigration court level. And because of that, the cases, other cases that wouldn't have needed to have waited for a decision, now will have to wait. So it's sort of a chain effect of one thing after another now. But basically, all of the cases that could have, just sat there for a while until they become eligible, are now going to be doing appeals. So it will most likely have the opposite effect of what was intended. The Immigration Nationality Act and the U.S. law that permits appeals and petitions for review for this very reason will go forward. And so we'll see what happens. Maybe Attorney Sessions will see what's happening and revoke his decision to not allow immigration judges to issue admin removal orders. Admin closure orders. So if you like the video, click like, subscribe, and more in the coming weeks. Thank you.